In today's video, we're going to talk about some questions and answers that I commonly get when people are being pursued by debt collectors who have purchased their debt. Debt collectors are purchasing billions of dollars worth of credit card debt, auto loan debt, medical debt, you name it. Debt collectors are in the market for buying that debt. And the reasons why a lot of original creditors sell off their debt to debt collectors is because they don't want to put the time and effort into pursuing and hunting down debtors who they had made loans to. Now, one of the things that I want to make you aware of is that the laws are changing, and it seems like it's going state by state. And I want to keep you up to date with some of the changes that are coming about, specifically for the state of Illinois. And I believe that Illinois is the test state for debt collectors, where they'll put money into one state to see if they can get the laws changed, and then they can, scale this out to other states. And so I make my videos because I know that you want concrete solutions on being able to deal with your debt, being able to help fix your credit and get you to where you want to be, because you don't want any surprises. You want to protect your money. You want to live a better lifestyle. You want better credit. You want to be able to get the things that you want using your credit, but you may not know where to turn. There's a lot of information out there, and you are looking for solid, concrete answers. And I believe that the information that I give to you, number one, is I'm giving you information on that I've actually used for myself in the past, and I've helped my clients with this. This is not stuff that is just made up and not tested, because I believe that that's important. And also, when I make my videos, I'm going to also throw in the feeling side. Like it's not just about someone coming after you for a debt. When you are under this type of anxiety, under this type of stress and pressure, it affects your life. It affects the way that you move through your day. It affects the way that you relate to your family, and your family can actually see this without you even saying anything. So I think that by watching this type of video, where I'm going to give you some real concrete answers on how to deal with this on a financial level, and also on a personal level with your thought process, so you can kind of manage your way through these types of issues. Because dealing with debt and debt collectors can be scary to some people, and some people it could be where they just like shrug it off. But having those consequences come down on you, regardless of how you internalize, regardless of how you show yourself on the outside to everybody, there could be some extreme consequences when it comes to not taking care of these debt collections or debt notices or debt lawsuits. There could be some extreme consequences. And so I'm going to start off the video with one where I received a letter from an individual in the state of Illinois. And this is the state that I believe is the test case for what debt collectors have planned across the United States. So now, when you get a judgment, let's just say that you were not in we're not in the didn't have the finances, didn't know what to do. Debt collector sent you letters. You didn't do anything. You didn't call them back. You didn't respond. You didn't do anything. And then all of a sudden you got a lawsuit. You didn't show up to court. You didn't write a response. And now you have a default judgment. they left you alone, like you just know that you had a judgment on your credit reports, and that's something that I've even went through when I was fixing my getting myself out of debt and fixing my credit, is that there were some judgments that were placed on me, and because they didn't pursue me right away, didn't do anything, I just thought, well, hey, I can wait this out. And at that time, back in the 1990s, I didn't know that it was a 20-year statute of limitations on a judgment. I was just like, hey, if they're leaving me alone, I can move on to the other stuff that I'm trying to work on and not deal with that. And at that time, I didn't even really know about making a response. So there's a lot of things that I've learned from going through my situation, and also over the years with the credit repair shop. So now you fast forward, you got this judgment on you, you didn't do anything about it, and then years later they come at you like this individual here. This judgment that he got was back in 2016, judgment by a debt collector. And not to say that person doesn't think that it could come back to haunt them in the future, but it's just that when this stuff seems to happen, it happens at the wrong time for people. It seems to happen when people are trying to work things out and trying to get back on their feet, and they got a little bit of breathing room. They're not paying out as much on their bills as they have coming in, so they feel real good about themselves, and then all of a sudden they receive a letter like this where a debt collector is pursuing them for a judgment that they had, and this one happens to even be with an original creditor, and they have this judgment against them that was back in 2016, and they have a notice of hearing where they want to revive the judgment. So when they motion to revive a judgment, this is when a judgment has been dormant for a number of years, and in some states it could be 7 years. In my state of Wisconsin, it's a 10-year. And so if a debt collector or the original creditor, they have a judgment against you and they don't revive it during that period of time, the judgment will not be renewed for the remainder of the 20 years or for whatever your state statute allows. But the statute of limitations on a judgment across the board for all states has been 20 years, which is a long time, 20 years. If they have a judgment, and then if they continue to revive it, they can revive it up to 20 years. Now, the state of Illinois has changed their rules. They have changed the rules to, number one, say that they can revive the judgment at any time. At any time they can revive the judgment. So say, for instance, it was past the statute of limitations period of 7 years, and I believe they have a 7-year in the state of Illinois. They had a 7-year. But with their new law, they can revive the judgment at any time, even after that period of time. But they do go through the motion to revive the judgment. There just isn't any statute of limitations. And the reason why they want to go through this motion of reviving the judgment is that usually a debt collector is either going to purchase that debt from the original creditor, and they want to get themselves, have the legal notice to the court that they're going to be the ones that's going to be doing the pursuing, or the original creditor just wants to put it on notice that they're going to pursue the debtor for that judgment. Like, they just want to put it on record. But what I found when I was doing my research for the state of Illinois is that they've actually got this to where they're going to allow people to just be able to be pursued at any time. So say you have 1 year on that debt, that judgment, and they pass that statute of limitations for reviving a judgment, it doesn't matter anymore in Illinois. It just doesn't matter anymore, which is, I think, I just think that it puts a lot of power in the hands of debt collectors who want to go out there and scan through all of the public files, all of the judgments that are out there that are just not being collected, which they have free access to that by utilizing Pacer and other websites. And then they're going to approach the original creditor, or if it was a debt collector that maybe was not pursuing it, maybe don't have the resources, they'll say that we'll put the resources together. Because the courts right now, the way that they're set, they're allowing debt collectors to raid bank accounts. They're allowing them to do garnishments, which they've always allowed them to do. And they have this new way that debt collectors are utilizing, going after assets that they can get. Now, certain assets are protected, and the laws have not changed on that. But I'm seeing a lot of people who have a LLC or a business that they have, and the tactic that debt collectors are utilizing is if you have any assets, let's just say even for you don't have a business, because most of you maybe don't have a business that's listening to me and you're like, this doesn't affect me, but let me show you how it does affect you. Most of the protections for your personal assets will stem to, like, if you have two vehicles, then one vehicle could be liable, where they could actually take that vehicle, because they'll look at your state statutes and they'll say, well, you could protect one vehicle, but you can't protect two. And then what most people, the thought process was, well, I owe money on that vehicle, on both vehicles, so you're not going to want to take any of the vehicles. If the vehicle was paid off, then it would be, maybe there would be an option for them to be able to do something. What I saw in one of the debt collector online conferences that they had, or Zoom calls, where they were talking about the different strategies that they're utilizing, and I was kind of spying for everybody, is that they were saying, okay, well, let's just say that they have a vehicle, and that vehicle, you do an assessment on that vehicle, and that vehicle is worth $10,000, and you do a debtor's examination, which is where you have to give them the information about your assets, bank accounts, and all of that stuff. So they do a debtor's examination. You don't do the debtor's examination, guess what they could do? They could put a warrant out for your arrest. So they're going to get that debtor's examination one way or another. So you put in there, okay, both vehicles are financed. They do a debtor's examination, and they do an assessment on both vehicles. They know that you can only keep one of them, and let's just say that one of the vehicles, they know they can go and sell that vehicle for, say, $10,000, and you only owe like $5,000 on it. Let's just keep it simple. What they'll do is they'll go and put a claim to get that vehicle, and then they'll pay off the $5,000 on that vehicle, and they'll usually have this already arranged. So it's not this type of thing where they're going to be like, look, we're going to go pay off that vehicle. Well, first seize the asset and have the court allow them to seize that asset, which they will get that get permission to do that. Seize that particular asset and then pay it off. No, they already have this arranged. They will find a buyer for that vehicle. And then they'll say, okay, well, as soon as we get the asset, we go and pay off the lender. So the lender is like, I got the money. It was seized. We're going to release the title because they're going to pay the $5,000. They already have a buyer for $10,000 on the vehicle. This is the way that they're doing it for businesses, to take assets from businesses, but they're also doing this on a personal level. That they're like digging down into ways that they're going to be able to go and get the money from people who owe money. They're not going to just sit there and just keep it the old-fashioned, old-style way, which is if you don't have the money and your vehicles are not paid off, or you got other assets that are not paid off, they will go and pay that off. Like, even if it's something where maybe you have a house in a condo somewhere, or Airbnb that you invested in, these people are doing these debtors examinations, and they will find what you got, and they're going to sit there and read through it and try to figure out a way to get their money, even if it's only a portion of their money. They don't care. That's what I want to get across to people. So now we got to be ahead of the game. We got to be proactive. That's what I'm about being. We have to be proactive so we don't find ourselves in these situations. And the gentleman who sent this letter from Illinois, very proactive, and the information that he put on here, we're going to be able to help actually stop all of the actions that they're going to try to pursue with just one letter. With just one letter. So now let's move forward and let's talk about what you need to watch out for when dealing with debt collectors. Because when a debt collector either buys your debt, or they're going to be hired by the original creditor to come after you for the debt, this is what they are required to do. And I'm going to talk to you about this, and you need to pay attention to it. Please like this video right now. I should have said that at the beginning of the video. Please like this video, because this is important information, and it can help you right now. And by you liking the video, you are actually helping other people. So now, when you usually get that debt collection letter, you'll be like, who the hell are you, and why are you contacting me? They're doing that because they have to send you this letter that's called legally a dunning letter. This is a letter that looks like it's a bill, but it's actually just a letter notifying you that you are being pursued by a debt collector. Now, from that letter, there are some things that you need to pay attention to. That letter must identify who the original creditor is. That letter must tell you everything about where they got that debt from. It has to identify their information, the debt collector's information. It must give you the opportunity to dispute any of it or all of it. And it must tell you the time frame that you have to dispute it. And if you don't dispute it, they're going to be able to put that on your credit reports, and that means that you are saying yes to the debt. I know it sounds crazy, but if you do not say anything, do not respond to that debt letter, you're actually saying that you owe the debt. I know it sounds crazy, but that's what it's saying. Now, another thing that you need to pay attention to is that from that debt collection letter, on that debt collection letter, they would be in violation if they didn't tell you any of that stuff. So if they're hiding anything about the original creditor, they're going to have the last four digits of that original account, who they are, how to dispute, and then the amount that you owe. And then also in there, the fonts cannot be different sizes. So they can't say real big, you owe, this is the amount that we say you owe, this is the original creditor, and then over here in a smaller font, you have a right to dispute any or all of this debt, and this is where you need to send it to. And they can't do that. It must be the same size consistently. As a matter of fact, these documents have to be approved by the CFPB, the Consumer Financial Protection Bureau. All debt collector letters are on file with the CFPB. So if they are in violation with that letter, you will not have to pay the debt if you respond to it the appropriate way. And you should always respond to a debt letter with a debt validation. I'll give you a letter that you can use it for that at the end of this video. Another thing that you need to pay attention to is the way that you get that debt letter. They cannot send it on a postcard. They cannot put anything like final notice or immediately open, none of that stuff. They cannot tell anyone on the outside what that letter is about. And that goes towards also them not being able to hire a third-party service to send those letters. Yes, they do it. Yes, they get away with it. But if you catch them, you will be able to have them cease collections, and they will send you a letter apologizing. You could go after them to get a $1,000 penalty fee paid to you. But if you owed $6,000 and they say that they're going to cease it and not sell it, that's like a $6,000 payout to you for them violating. The next thing is, do you really owe the debt? That goes into doing a debt validation. When you do a debt validation, it needs to have information about how they have the right to come after you for the debt. If it's a debt collector who purchased the debt, they need to give you certain documents that are required during that transfer of the debt from the original creditor. Don't worry about it. I'm going to give you a letter so you can get that information from you. Can they prove that the debt is yours? That's part of the debt validation, that you have a right under the Fair Debt Collections Practice Act to do a full debt validation. And part of that debt validation is them, the debt collector, showing how they know 100% that the debt is yours and the amount that they're claiming is your debt. Next thing is that you want to always look at your state's statute of limitations for collecting a debt. This is for collecting a debt that is not a judgment. There's different laws, different time frames for each state. My state of Wisconsin is 6 years, and some states have it lower if it's an open-end account like a payday loan or a credit card debt. It could be lower. Some states have it as low as 3 years. If the debt is past the legal statute of limitation, there is no need to do a debt validation for the debt. You are notifying that debt collector that they have a debt that is past the legal statute of limitations for them to be able to collect according to the laws in your state. Don't worry, I'm going to give you that letter at the end of this. Now, let's just say that everything is right. You know, everything checks out. You are of the mindset of wanting to move forward. I was of the mindset of wanting to move forward, and that means that some debts from debt collectors you're going to have to go ahead and pay and resolve so you can move forward, because it's not about staying stuck. It's not about running from the debt. It's about verifying, validating, and then looking at your options to move forward. So now, will paying a debt collection affect your credit score? Well, number one, it's going to affect your credit score by them having it on your credit reports as a collection. If you look at your credit reports, and a lot of the free credit report services don't show this, but this is something that is very valuable information for you to know, and it goes towards why your credit scores could be low. There's a section on the credit report service that we provide to our clients, that we recommend to our clients, and it'll say collections. Whenever the computer algorithm for each of the credit reporting agencies, TransUnion, Equifax, Experian, when they scan through what's on your credit reports, the trade lines, and they see that a debt collector has put an account on your credit reports and it has the word collection on there, that's going to hurt your credit scores. So if it's an open collection, that's going to hurt your credit scores. So if you do not know if that's the way that it's reading on your credit reports, I invite you to go to the3scores.com to grab your TransUnion, Equifax, and Experian credit reports, and you will see right there in the summary, it'll say delinquent accounts and it'll say collection accounts. Those two sections right there is like the main problem why your credit scores are low. You got to figure out how you're going to resolve the issues that are in those sections right there. So now, if you pay the collection, if it's a debt collector who purchased your debt, 99% of them, really 100% of them, if you pay the collection, they will remove it. Now, there might be some haggling back and forth. You want to pay a lower amount. They might try to haggle and go up a little bit for the removal, but they will all remove it. And then even if they don't, you will be able to utilize the documentation to get that removed. There will be no reason for them to keep that on your credit reports. And if it's an original creditor that you pay off and they put paid, settle for less, or paid in full, whatever that is, that's going to allow the algorithm to read your scores, because it's not going to say that it's an open collection. A lot of people, I know there's a lot of people out there, they'll be like, don't pay it, it's not going to help you. I see it every day. When people do that and they pay it, it does help. What usually, what the problem is getting to that resolution process without opening yourself up to a whole bunch of other stuff that you don't want to tell debt collectors. That's why people will usually come to us, because they're like, they're going to ask some questions that I don't want to put myself into the position to answer. And you would be thinking properly with that, because that can either hurt your chances of getting a very good settlement, but also if they're dealing with other accounts that they might have in your name. And you better bet that debt collectors have some sort of system internal, and that where they can look and say, hey, if there's they got information on someone. And remember, these companies work with each other. Like, you'll have Resurgent, Sherman Acquisition 1, 2, and 3, LVNV. All of these companies are really under one umbrella with a lot of them. And if you give them certain data and information, you better bet they're going to comb through to see if there's any other debts that you have, and they're going to use that information against you. That's why you got to be very careful when dealing with these debt collectors. As a matter of fact, one of the things that you should do right up front, which is something that we do, is we say, are there any other accounts that you have with this under this individual's name? Because then you can know what you're going to try to put in place without messing up anything and estimating what your client has, or you, if you're doing it yourself, overestimating what you got, and then all of a sudden you make a settlement with one, and then they're coming right around the corner with the other debts that they have in their database. The next thing is, can you settle a debt for less than the full amount with a debt collector? Yes, you can. And again, these are questions that people ask me a lot on my YouTube channel. Yes, you can settle it for less, but you're going to have to do a little bit of back and forth. Will you get sued if you don't pay? Yes. Well, I would say it depends on the debt. It not always, but it does depend on the debt. But I can tell you this, is that they cannot threaten to take legal action if they do not intend to take legal action. That is actually in the Fair Debt Collectors Practices Act, that they cannot threaten to take legal action if they don't take legal action. Now, here's the crazy thing, is that what if you say, okay, they threaten to take legal action, how long should you wait before you consider that a violation of the Fair Debt Collectors Practices Act? I usually give it 30 to 45 days. If they do not take legal action in 30 to 45 days, I would put them on notice that they're in violation of the Fair Debt Collectors Practices Act by threatening to take legal action, and they did not intend to take legal action. Now, if you had a debt collector threaten to take legal action and it's like 60 days out, a year out, you could go back around, because remember, we want to be in the mindset of resolving this stuff and not having stuff come back later. Is you can go to them and say, you threaten to take legal action on this date. If you have something to be able to prove it, and then you can draft up your letter, send a certified mail directly to their legal department, and let them know that they're in violation because they made a threat, and they did not intend to take legal action. Can they garnish your wages or seize your assets? I just spoke a little bit on that earlier, but yes, they can garnish your wages, they can freeze your bank account, or they can seize the funds in your bank account. They can do all three to be able to collect. And I will throw in that, like I talked about earlier, where even if an asset is not paid off, they can do that debtor's assessment, examination, and then do a assessment of your asset and see if they're able to take that asset. Another question that I got is, what happens if you can't pay right now? What I tell people to do is you need to let them know your situation, because debt collectors actually have this written within their websites where they say that they will listen to all hardships. And so what I would say is you need to open up the communications with them and let them know. Now, something that could happen from you doing that is that they could ask for a debtor's examination where they want you to fill out some documentation. But if you're really in the situation where you cannot pay your household expenses, you're barely able to meet those, you might want to consider going ahead and doing that. Another question people ask me, and I just spoke a little bit on this, how will it reflect on your credit reports if you pay or settle a debt? They will usually put on there settled for less, or they will put paid in full, whichever way you do it. But the big part is that the algorithm is going to read that account is resolved. And if you're trying to buy a home, let's just say that you're trying to buy a house, and they didn't remove it, but the mortgage company, the underwriting department said, if you take care of that collection, you're good to go. That is true. I've seen that happen for people. If you resolve it, it does not have to be removed. They will just say that it's resolved. That's what they care about. If they don't want to give you a loan, and then you had this open account that's unresolved, that's going to come back and make your situation worse with the risk factors of you being able to afford to make the payments on the house. If it's resolved, that's all they care about. So yes, if you pay debt collection, it could either be placed on there that is paid or settled for less. Can you stop contacting me? Debtors often want to understand their rights under the Fair Debt Collectors Practices Act, the FDCPA, to inquire on how to stop debt collectors from contacting them further, even though a cease and desist letter or opting to deal with the original creditor directly. Now, when you have a debt collection, this is one of the most misunderstood aspects of dealing with a debt collector who has purchased your debt. Is a lot of people think that sending a cease and desist collection letter, cease and desist letter to the debt collector, because they want to try to open up the communication with the original creditor. You will find that when you submit information or you try to contact the original creditor, they're going to send you right back to the debt collector because they have sold that debt to the debt collector. Also, some of the times, if the original creditor still maintains the debt, and you try to contact them, they're going to still send you to the debt collector, because in some states it is illegal for the original creditor to actually act as a debt collector. So they have to, by law, get a debt collector to pursue you to collect on that debt. So sending a cease and desist a letter to the debt collector will stop them from contacting you, but it's not advised, because they're potentially going to move forward when they speak to their client, and they're going to say, well, would you like us to just move forward with suing them with this? Now, what I would advise people to do is to have them cease and desist all calls and only deal with you by mail, so you can get all of the information from them and have that back and forth without exposing yourself. Another question is, can you get a written agreement before paying? Yes, when you're dealing with a debt collector or any settlement, you can get a written agreement with the terms of the settlement. You should always do that, so you can make sure that everybody is on the same page. So yes, you will, if you tell them, hey, I'm not doing this settlement until I get something in writing stating what our agreement is. And then once you have that agreement, you move forward. And, to this day, I have not ran into any debt collectors, once they give you that agreement, that they're not going to move forward with that agreement, that they're going to try to do something sneaky with you. Not to say that there's not some out there that might do it, but I think that the way that you approach them, the way that you negotiate, all of that plays in a big part of the way that they're going to be understanding or getting awareness of your understanding about what your rights are when dealing with a debt collector. Another thing is, what are my rights if I think you're being harassed by a debt collector? You have a lot of rights, and the number one thing that you need to do is you need to document what you believe the rights that are being violated by the debt collector. And then you need to look at the Fair Debt Collections Practices Act, and then you also need to apply some common sense, because one of the ways that I found with dealing with debt collectors that with some of my clients, one of the number one violations that we were able in the past, a lot of the debt collectors have kind of tightened up on this, but in the past we were able to get a lot of debt collections like totally ceased, where they're not gonna pursue the individual based off of this terminology. And if you've had a debt collector call you and say something like this is a violation, but it would kind of slip the mind of an individual, because when they get you emotional and they slip this in, it doesn't really sound like a violation. So in a back and forth conversation, debt collector, hey, why don't you pay your debts? Don't be a deadbeat. It's not good to not pay your debts. That is a violation. That is harassment. So you might be thinking that that's just like back and forth conversation, but that is a violation according to the Fair Debt Collection Practices Act. They must remain 100% professional and stay within the wording of, hey, what is going on? When can you pay? That's why you'll know a very well trained debt collection representative when they do this. They will say words like, first they're going to give you your mini memorandum, which is saying that this is attempt to collect the debt. Anything you say can be held, all that stuff. That's called a mini Miranda warning for debt collectors. They're going to give that to you. But then they're going to say, this is the amount that you owe, and when would you be able to take care of that, or are you looking to set up a payment arrangement? Like, they're going to be very direct with what they do. They're not going to get into, why aren't you paying this debt? You owe this company $5,000. Why aren't you paying it? You should be paying your bills right now. You're probably paying other stuff. Why aren't you paying this? A very well-trained debt collection representative will not go out those bounds and start making it something where it seems like they're trying to get you aroused and emotional and personal. But it does get people emotionally involved with the way that they stay straight on point with the debt, because what happens to the individual is that you feel like the person does not care anything about what you're going through. It's a crazy thing. This I know this from experience with dealing with this with my clients, dealing with this for myself in the past. And in the past, when I went through it in the 90s, they were able to really say anything to you. And I didn't even really know my rights. It was just mainly about trying to get to a resolution. Now, because they've been sued, there's certain things that they got to watch out for. Recording devices are all over the place, so people can get evidence a lot easier, utilizing cell phones, utilizing a whole bunch of things, email. So they're going to be very careful. But the crazy thing about it, the way that we are as humans, when we speak to someone, if they seem like they're not even have any care in the way that they're talking to you, it can make you get kind of upset and emotional, and it has the same effect that it used to have when they were saying, why don't you pay your debts, you're deadbeat, you should be paying your bills, like that type of stuff. It really has the same effect, and I think that they've learned that, because the way that they stay on point with stuff makes it like they have no feeling or no care in the world about what you are going through. Like, they have no feeling at all. Like, it's just like it is what it is, and when are you going to pay us the money for our client, or pay us the money for the debt that we purchased, and you got to deal with it. That's what happens. But if you can document that any violations that where they seem to have stepped out of bounds, you can write to their legal department. You need to send that certified, or you can hire an attorney if you have one in your area. And just get them, number one, if you can get them to stop pursuing you for the debt, and put in writing that they're not going to sell the debt to another debt collector. A lot of my clients that we've been able to do that for, they feel that that's a win for them, and that's like a payoff. All right, so if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, your3scores.com to grab your TransUnion, Equifax, Experian credit reports, and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters. Statute of limitations letter, for debt that is past the legal statute of limitations to collect. You can go to my website, thecreditrepairshop.com, click on the blog that's at the bottom, type in statute, and you'll see the statute of limitations for all 50 states. If your debt is past the legal statute of limitations, no debt validation is necessary. Just utilize that letter. If your debt is not past legal statute of limitations and you receive a debt collection letter, use the cease and desist collection activities letter first that I give you, to try to see if you can stop them, and then if they come back at you, use the debt validation letter second to ask them more questions about proving that they can legally come after you for that debt. I do ask for a donation on those letters. It helps me monetize my time here on YouTube, giving you this great information. Please like this video, subscribe to the channel if you're not a subscriber yet. Thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.